Rule 60(b)(2) is part of the Federal Rules of Civil Procedure (FRCP) in the United States, and plays a critical role in the justice system. This rule enables a court to relieve a party from a final judgment, order, or proceeding based on newly discovered evidence that, with reasonable diligence, could not have been discovered in time to move for a new trial under Rule 59(b). Distinct from an appeal, Rule 60(b)(2) isn't about arguing errors made at trial. Rather, it is a rule invoked when something outside the initial proceedings has taken place, or when critical information has surfaced that was not accessible or known during the trial. The rule is divided into two critical parts: newly discovered evidence, and the due diligence requirement. In terms of newly discovered evidence, this suggests that evidence has come to light post-trial, which was unknown to the party during the proceedings, and is sufficiently potent as to potentially alter the original outcome of the trial. The second part, due diligence, refers to a reasonable effort a party should have made to discover evidence. This does not mean exhausting all possible means, but rather making a fair and sensible effort to discover the evidence before the trial's end. If Party B didn't know about certain evidence because they ignored clear signs or didn't ask simple questions, their motion will likely fail since this does not constitute reasonable diligence. Application of Rule 60(b)(2) is delicate and necessitates compelling evidence to persuade a court to even consider reopening a resolved issue. A mere doubt about the correctness of the judgment wouldn't suffice. Particularly, the evidence needs to not only be new and previously undiscovered despite reasonable efforts, but also potentially decisive in the case's outcome. If the new evidence wouldn't result in a different outcome, the motion will not be successful. It requires a strong and compelling argument to persuade a court to set aside a judgment or order on this ground. As such, when filing a motion under 60(b)(1), a party should always include a brief of authorities and argument in support. Also, the party making the motion should request oral argument when the motion is filed. Finally, Rule 60(b)(2) motions must be made within a reasonable time, requiring a swift response once the new evidence is discovered. Although this rule offers an opportunity for reconsideration of judgments, it emphasizes due diligence and proactive conduct from all parties involved. Thanks for joining us today. Remember, what you learned today is for informational purposes and should not be considered as legal advice. If you found our content helpful, consider subscribing to our channel for more legal explainers like this one.